Generally, an actionable misrepresentation is a statement of material fact made prior to the contract by one party to the contract to the other, which is false or misleading, and which induced the other party to enter into the contract. Consequently, a contract that was induced by a misrepresentation will be rendered voidable at the option of the innocent party. In order to constitute a misrepresentation, several key elements have to be achieved. Firstly, there needs to be a false statement, and the false statement has to induce the other party to enter into a contract. Furthermore, the representation statement must be unambiguous and false. The statement made must be one of fact or law. Thus, it must not be a promise, an opinion, a mere bluff, or a statement of intention. Subsequently, the representation must be addressed to the party misled directly or indirectly with intention, knowledge, or notice in an actual or constructive manner. According to Ian McKendrick, English law does not recognize the existence of a general duty to disclose information during the process of contractual negotiation. The process of contractual negotiation is not left unregulated. Rather, a duty is imposed not to make any false statements of fact or law to the other contracting party and thereby to induce him into the contract.
Having said that there is no general duty to disclose material facts during negotiation, there are, however, a few exceptions to the rule in which there is a duty to disclose material facts. First of all, a representative has a duty to disclose a material fact when there is a pre-contractual misrepresentation. This refers to a situation whereby a statement made by the representative was correct at the time of the negotiation process, but only later before the contract was concluded, the representative finds out that there was a misrepresentation. As seen in the case of With and O'Flanagan, which involved a doctor making a sale and purchase agreement of his medical practice with the plaintiffs. At the start of the negotiations, the doctor and his agent made a statement that the value of his practice was high, but subsequently the value of his practice dropped during the 4-month interval between the time the statement was made and the date where the contract were to be concluded. Due to him being ill, the courts held that the contract could be rescinded and thus the plaintiff's claim succeeded. Lord Wright gave two explanations for the reasoning of this decision, firstly known as the duty to communicate approach, whereby a representative should communicate the misrepresentation to the representee upon learning of the changed circumstances. Otherwise, he would be held liable for creating a false impression that led to the representee to rely on his statement to conclude the contract. The second approach is known as the continuing representation approach, to which Lord Wright relied on Lord Cranwell's view in Smith and Kay that a representation made as a matter of inducement into the contract should be treated as a continuing representation. This is due to the fact that a representation once made often has already influenced the mind of the representee. The relevant time for testing falsity of a representation is when reliance is induced by the representer to the representee, and therefore if there is a misrepresentation, there is a duty by the representer to disclose it to the representee. Furthermore, the courts held in the case of Spice Girls and Aprilia World Service that the Spice Girls were liable for damages under Section 2, Subsection 1 of the Misrepresentation Act when one of the members continued to attend photo shoots despite having an intention to leave the group soon after. It was held that attending the photo shoots amounted to a false statement of fact. Next, my friend Chenru is gonna talk about another exception and its reforms.
Another exception to the general rule that states that there is no general duty to disclose material facts is where it falls under the contract of insurance. Generally, insurance contract falls under the category of contract of uberrimer fide, which is also known as utmost good faith. As it is a type of contract with utmost good faith, the fullest confidence is required from the two contracting parties in terms of fairness, reasonableness, and ethical dealings. Thus, this doctrine of uberrimer fide imposes a duty to disclose material facts. As an example, in the case of Carter and Boehm, the principles of utmost good faith in contract of insurance was expressed by Lord Mansfield, where he had stated that the underwriter trusts his representations and proceeds upon the confidence that he does not keep back any circumstances in his knowledge. Subsequently, the requirement to disclose material facts in this doctrine raised an issue on the determination of what constitutes a material fact. Under Section 18, Sub 2 and 20, Sub 2 of the Marine Insurance Act 1906, the legal test of the materiality of a fact is stated to be one which would influence the judgment of a prudent insurer in fixing the premium or determining whether he will take the risk. However, there are also various tests that was found on common laws to determine a material fact. Take the case of Maine, Nicholas, and Flagler. It was held that the test to be applied is not what the assurers think, nor even what the insurers think, but whether a prudent and experienced insurer would be influenced in his judgment if he knew it. Meanwhile, from the case of Pan Atlantic Insurance Co. Limited and Pine Top Insurance Co. Limited, the settled position was that even if a particular insurer did not regard a disclosed fact as material, if a prudent insurer would have regarded it as material, the particular insurer was not precluded from avoiding the contract for non-disclosure. With all these different tests, the rule of duty to disclose material facts is once again being challenged. Moreover, according to the English Law Reform Committee in Fifth Report, many facts which consider material to the insurers would not appear to even an honest and careful proponent to be facts which he or she ought to disclose. In order to address the issue above, reforms were introduced by the Law Commission recently, where two legislation was introduced. The first legislation was the Consumer Insurance Disclose and Representation Act 2012. This act applies to consumer insurance and set out what happens if a consumer gives incorrect information. Through this act, the rule that the insurer must disclose all material facts within his actual knowledge was abolished. Instead, the new rule requires the insurer to ask appropriate questions and the consumer must answer them honestly and carefully. The second legislation was the Insurance Act 2015, which applies mainly to business-related insurance policy and consumer insurance. A new duty to make fair representation was introduced in this act, where the parties are required to disclose all material circumstances which it knows or ought to know. Next up, my friend Jake is going to introduce the Malaysian segment of duty of non-disclosure.
Misrepresentation as a whole is defined by K. Arjunan and A. Majid as a representation that is a term of a contract which turns out to be false. And they further state that the representee has a remedy in an action for breach of contract. Dr. Irwin Ooi reports that the definition of non-disclosure, as given by Arnolds, is non-disclosure in the law of insurance is the suppression of or neglect to communicate a material fact within the knowledge of one of the parties which the other has not the means of knowing or is presumed not to know. Similar to the UK, Malaysian law does not recognize a duty on parties to a contract to disclose material facts. This is expressed under Section 17 of Malaysian Contracts Act 1950. However, there are exceptional cases where duty is imposed. These exceptions include fiduciary relationships, contracts uberrime fide, family settlements, silence, and when a representation is true but subsequently turns untrue. Malaysian courts have adopted the Obiter Dicta from Bell and Lever Brother Limited. It was expressly approved in Lauhitia and Harjil Engineering Sendirian Berhad and another. The said obiter states that the exceptions in which duty to disclose is present are in contracts of special fiduciary relationships, contracts for partnership, and contracts of insurance. Tokim Lian and another, and Asia Insurance Company Limited, was a case that exemplified the duty to disclose was present. The assured was involved in an accident but did not disclose in his insurance renewal that he had been suffering from life-threatening illnesses. Additionally, the court also held that there is a duty to disclose in an insurance contract only insofar as to the knowledge of the assured at the given time, given that it is not reasonably expected. It is also important to note that there is no post-contractual duty of disclosure. Malaysian insurance contracts are governed by the Malaysian Insurance Act 1996. The legislation takes inspiration from the Australian Insurance Contracts Act 1984, shunning the concept of materiality from English common law. The concept of relevance can be seen in Section 150, Sub 1 of the 1996 Act. Before a contract of insurance is entered into, a proposer shall disclose to the licensed insurer a matter that A. he knows to be relevant to the decision of the licensed insurer on whether to accept the risk or not and the rates and terms to be applied, or B. a reasonable person in these circumstances could be expected to know to be relevant. The concept of relevance can be seen to have provided leeway for the subjective reasoning of the courts. Words such as relevant and the entirety of whole subsection B allows the courts to use their discretion to determine what is material and what is not. Gan argues that under this section, the concept of relevance undermines the common law concept of materiality and takes precedence over it in the jurisdiction of Malaysia. Material facts in the context of Malaysia relates to the physical or moral hazards pertaining either to the subject matter of insurance for the insured. For example, in the case of Wong Lang Hung and National Employees Mutual General Insurance Association Limited, it was held that the fact that the building insured was connected to another building is a relevant and material fact that should have been disclosed prior to the contract. Additionally, the past record of insured's health was considered as material fact in the case of Goh Chui Leong and Public Assurance Company Limited. Family settlements are also an exception where there is a duty of non-disclosure of material facts. In the case of Lim Kim Hua and Ho Chui Lau, the plaintiff and the first defendant were in a close relationship, as the defendant was highly dependent on the plaintiff. It was held that due to the closeness of their familial relationship, the duty of non-disclosure is present. The final exception in the jurisdiction of Malaysia is in regards to silence. Section 70 sub E of the Contracts Act states that any such act or omission as the law specially declares to be fraudulent and is further explained in the explanation section as mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud, unless the circumstances of the case are such that, regard being held to them, it is the duty of the person keeping silence to speak, or unless his silence is in itself equivalent to speech. To elaborate, illustration C provided under the Act states, B says to A, if you do not deny it, I shall assume that the horse is sound. A says nothing, and here, A's silence is equivalent to speech. The second scenario where silence may alter the duty of non-disclosure is when silence regarding an undisclosed fact, half-truths or partial disclosure, gives a false impression. An example of this is the common law case of the King and Kilson. where the prospectus of a company did not disclose the fact that they have been paying their dividends out of their reserves and not their profits. This amounted to fraudulent misrepresentation. I will now allow my friend Li Shen to discuss the issues and reforms within the context of Malaysia.
Even though this doctrine has been in effect for a while in Malaysia, there are still a few issues that may arise in the practice of this doctrine. The first issue that arises is from when there are products that require a certain technical expertise. So when it comes to products that are industry specific or specific to a certain job or hobby, it can be said that the buyer cannot be aware as they do not have the amount of understanding as to be able to be aware of the dangers or things to look for when buying such items from various sellers. This would be important as the customer would not be able to estimate the fitness of the product for a particular use. This is the case especially in the contracting to purchase items without being able to inspect them first. The issue here is, in most cases of this nature, they would not know what material facts they would have to be aware of, let alone the industry standard specifics of the items in question. Neither would they have the ability to discover the truth, as it is foreign to them, where circumstances show that the consumer not only fails to rely on the supplier's skill or judgment, while the supplier maintains his silence, even if they know that the product is inappropriate for the consumer's purpose, it will result in the consumer being unprotected by the Consumer Protections Act, making them vulnerable to injustice. Another issue that arises in the presence of standard form contracts, which are becoming more and more common in recent times, where there are only standard contracts that the consumer may only choose between acceptance or rejection and do not have the negotiating power to vary the terms of the contract. The issue arises as in some of these contracts may have unfair and unreasonable terms that the customers wouldn't have any say in. This will give the sellers the freedom to do as they please in concocting their contracts. This is more of an issue in the Malaysian context, as there is nothing similar to the Unfair Contracts Terms Act, ACTA, that is enforced in the UK. So in trying to resolve these issues, there are a few reforms that can be pursued. One possible reform that we will be addressing today is the doctrine of caveat venditor. This maxim holds the meaning of let the seller beware. This moves the duty from the shoulders of the buyer to the seller. It would then be considered to be the duty of the vendor to ensure that the quality of the product is suitable and that it carries no defects that are material to its function or be held liable for it. The origin of this principle is the UK, but it can be preferably applied to Malaysia. And the absurdity that this reform would try to fix is seen in the illustration to section 17a, where there is a horse which is of an unsound mind being sold to another person. This did not amount to a misrepresentation or fraud, as the seller did not mention anything about the unsoundness, which could have been considered an unfavorable quality or a defect. The seller would be free from any liability, which would cause injustice to the consumer, as he could not have known of the issue of the unsound-minded horse. However, this defect in the product that he was selling can be said to be a material fact that the buyer would not think to ask of, which is not different from the first issue that was pointed out earlier. So this would lead to unfairness and unjust enrichment towards the seller from being able to sell the horse at a price greater than what it was worth from something that is merely his failure to disclose another perspective. Another perspective is that of the buyer having to pay more for no reason other than the fault of the seller, while the buyer is unable to take his own reasonable effort to discover the truth. This is what doctrine of caveat venditor can attempt to remedy.
In conclusion, we propose that it is not entirely true that there is no duty to disclose material facts. There are exceptions that bypass this general rule, which vitiates the contracts that are formed. If there is no agreement on the material facts that are not mentioned, it can be said that there is no consensus and idiom, which is the most important requirements in a contract. That being said, this doctrine has its merits, especially in contracts that require ubrimae fidei, which, like what has been discussed prior to this, it is not useless, but it also causes a lot of issues as well as allows for certain unjust enchantments. Therefore, it can be said that the general rule is an important one in UK and Malaysia, and it should be maintained.